Good morning, folks. It's Andy Stautz at Stautz Law. I'm back for another Indiana probate administration topic, and this one has been a long time coming. We are talking today about devolution affidavits. And devolution affidavits are a tool that you can use in certain circumstances to record a transfer of property from a decedent, someone who died, to their intestate heirs. It's an important qualification, without a formal probate administration. This topic is kind of a minefield because there's a lot of gray area in terms of when and how and whether it's the right thing to do. So we're going to talk about what a devolution affidavit is supposed to do first, and then we'll kind of talk about some limitations, and then we'll kind of talk about how you decide whether it's a good idea. So at its most basic, a devolution affidavit is just giving effect to a provision in the probate code that says when a person dies, their stuff goes to their heirs. Like, that's the basic rule, right? But to understand what happens next, you need a bunch of legal concepts. Basically, there are a bunch of exceptions to the general rule. So the general rule is when you die, your stuff goes to your heirs, except the personal representative, if there is one, is in charge of administration. Except a will doesn't take effect unless it's been admitted to probate. Creditor claims, title passes except it's subject to creditor claims until the 9-month absolute claims bar, and so forth. So a devolution affidavit is basically supposed to say, here's how that title passed, and here's why none of those exceptions are going to be a problem for us now. So we talked a few weeks ago or a few days ago about small estate affidavits. If the total estate's less than $100,000, you can use this one pager to get personal property. Okay, well, what about real property? The devolution affidavit is basically the answer to transferring real property without probate. It's not subject to that $100,000 small estate limit, but it's subject to some other conditions. Okay, so those conditions are set out in 29.1.7.23. Just pulled up that code citation for you. And that's where it says, okay, you can record an affidavit, just like a deed, that says this property was owned by the decedent. These are the these are the heirs, and that can be one person or many people. Here's how it descends. And you record that, and it's effective as a transfer. And then if after the time limit for opening a probate estate comes and goes, and the creditor period comes and goes, then it's like, okay, nothing can disrupt this now. So it's final. So anyone else who wants to buy the property or whatever can do it without worrying that a personal representative is suddenly going to open an estate or a creditor is going to come forward with the claim. So some of the gray areas are, of course, like how final is that, really? Because unlike probate, where there's a formal procedure and the court is at least a little bit involved in granting the petition, and you're pretty much just relying on whoever makes the affidavit to say so about who gets the property and why. And as we've discussed in the past, there's this escape hatch in the probate code that says you can probate a will to prove passage of title of property that's still titled in the name of a decedent. In theory, the devolution affidavit should defeat that, because once it becomes effective, the property's no longer titled in the name of the decedent. But in practice, some title companies are a little leery of this. Some realtors don't know how to work with it. But to sum it all up, what you kind of need to know is there a will? Because if there's a will, the rules say you have to probate it, so no devolution affidavit for you. Is there potential family conflict? If so, probably no devolution affidavit for you, right? You don't want to be part owners with a bunch of people who don't get along. Are there other assets that would make a formal administration a better idea? What are your plans in terms of sale? Does it, if you're just staying in the house, then maybe, you do devolution affidavit. You don't need to get along with your seller. So there are a lot of considerations, but it's kind of this backdoor method to pass real estate down. If there's no will, all you're trying to do is move the property. And, it gains finality once the time limits pass for everything else. I hope that was some consideration of what's out there. A full discussion of how the title passes and when it's perfected is, I think, requires a legal background. But that's kind of the overview. Hope it was helpful. And if you've got questions about this, I do them all the time. I, decide whether probate's appropriate, decide whether devolution affidavit is appropriate, and, write and charge accordingly. So give me a call if you've got questions. This was an overview. I can give you specific advice if you are my client. Thanks, and bye.